it also provided that the working and the procedure would be prescribed by Act and by regulations under the Act. The Act provided that if any two members in the 6-member body had reservations about a recommendation, that recommendation would not go through, which was considered a veto, but it was really a special majority, that you needed a majority of 4 out of 6. But please remember that this provision in any case was in the Act and not the Constitution Amendment. But the Constitution Amendment has still been struck down on the ground of there being a veto, though in the Act, but the Act and the Amendment are part of a package deal, and therefore both must go. Now, what is the basis of the judgment of the majority? There are 4 judgments, and therefore it's confusing, but we have tried to cull out as lawyers. Independence of judiciary is part of the basic structure. The process of appointment of judges is a necessary part of the independence of judiciary. Primacy of the judiciary is a necessary part of the process of appointment, which is integral to the independence of judiciary. This primacy is taken away by the Constitution Amendment, and therefore the basic structure is violated. The amendment is bad, the Act is bad, period. Now let's come back to the 4 professions which I referred to. Primacy, therefore, is not part of the architecture. It's not part of the structure. It is supposedly a part of a wall, and the primacy is gone because the judges are 3 out of 6. They don't have the majority to overrule the decision, the view of civil society and the executive, and therefore primacy is violated. Now one is, therefore we are coming to bricks and we don't confine ourselves to the structure, contrary to the Supreme Court's own view in dealing with challenges to other constitutional amendments. So there are double standards here, because there have been very few instances, 4 or 5, when the court has struck down constitutional amendments, where the court has said it has to be some overarching principle which is violated before we can strike down a constitutional amendment on the ground of violation of basic structure. But when it came to the court's own perception of judicial independence, it said goodbye to that test. Now let us assume, for the sake of argument, that yes, primacy is part of the basic structure. But what does primacy mean? When the amendment gave an institutional majority to the judiciary, that is 3, and deliberately opted for giving institutional minority to the executive, 1, and institutional minority to civil society, 2. Weren't the requirements of primacy met? If you have an institutional majority, wasn't the requirement of primacy met? Apparently not in the view of the Supreme Court, because primacy must mean their overwhelming majority, their veto. This, I submit, is a deeply flawed view and a self-serving view. Now, let me come to the next point. Why is it that outside participation is necessary in the process of judicial appointments to a judiciary which enjoys such vast political power? The first is based on the doctrine of checks and balances itself, which is also part of the basic structure. If the judiciary can strike down laws of parliament passed by elected representatives of the people, surely there ought to be an element of democratic participation in appointment of those judges in whom such vast power is vested. Vested by whom? By the people who have created this constitution, who have created these courts. So the checks and balances theory requires that there must be an element of democratic participation in the process of judicial appointments. Secondly, independence of judiciary is very narrowly viewed by this judgment and by our robed fraternity generally as independence from executive interference. Now, independence from executive interference is only one aspect of independence of the judiciary. The independence of the judiciary also means judges must be independent of corporate houses, of business lobbies, of lawyers, of law firms, and most important, judges need to be independent of themselves. Independence from themselves means independence from their own prejudices and proclivities, independence from caste and religious considerations, because after all judges are drawn from the same society, independence from the career interests of their own kith and kin. Who is to interrogate judges on these aspects unless there is outside participation? Then comes the question of the social philosophy of judges, which is something essential in a constitutional court. Now, I think a large number in this audience would have been shocked at the judgment of the Supreme Court in the 377 case. Now, why did that happen? Because there was no one to interrogate prospective Supreme Court judges on their social philosophies. So let's not get scared by this word social philosophy. I am saying this particularly because those of us who grew up, who came of age in the 70s, were taught that social philosophy is a bad word, because when Mrs. Gandhi wanted to supersede judges who did not see eye to eye with her in her socialistic reforms, one of Mrs. Gandhi's ministers, the late Mohan Kamaramangalam, who was not the law minister, but he is the one who articulated this with great candor and honesty, that the social philosophy of judges is important. And we thought that was something dirty, because social philosophy meant that courts were going to be packed with judges who are convenient to the executive. But social philosophy, as we see now, means much more. And therefore, judges need to be interrogated on their social philosophies, and this can only be done with outside participation. The last important reason for outside participation is that judges, when they self-select, are only giving each other a chance to make it. And that's why you have this completely ridiculous spectacle over the years of Chief Justices of India who have held office for 17 days, 30 days, 3 months, Chief Justices who have been sworn in high courts for even 1 day and 2 days, so that they could reach that particular scale for the purpose of their pension. On the one hand, you say that the CBI director must have 2 years, the Home Secretary must have 2 years, Foreign Secretary must have 2 years, but the Chief Justice of India, Chief Justice of High Court don't have to have a minimum tenure. The point I am driving at is that the concept of manpower planning in the interest of effective functioning of an institution is completely alien to the minds of judges when they sit and self-select. There is another interesting concept which I read about in the context of a rise in hierarchies in the field of business management. The concept of homosocial cloning or homosocial reproduction, and this has been studied in the context of gender discrimination, women not rising in an organization, or blacks, Hispanics, etc. When a homogeneous body self-selects, it subconsciously selects people in the same mold people like us, PLU, why does a judge like a particular young lawyer who is appearing before him? Because he sees himself as a young lawyer. He sees his own young days. It is that kind of a lawyer who makes an impression on him. This is a fact of human nature, and therefore, as a check on homosocial cloning also, the importance of the outsider cannot be forgotten. Now this judgment, apart from, and I'll just give a brief analysis for the benefit of lawyers and law students present in this audience, and then come to my concluding point. This is for lawyers now. For the future of the basic structure theory, this judgment opens up frightening possibilities. One is this concept of derived basic structure, the brickwork of the basic structure. Secondly, the comparison between different pillars of the basic structure and the judicial fiat, that it is not an express fiat, but if you have to choose between different pillars of the basic structure, then the independence of the judiciary is the most important. And the third is that in matters involving the judiciary itself, there is going to be a significant lowering of the threshold as far as applying the basic structure theory is concerned. Now you can forget all about overarching principles. Anything which the judges feel affects the judiciary can be brought in within the basic structure concept. So that is for the lawyers and the legal academics here to ponder over. Now to civil society, I would want to highlight the fact that this judgment shows a certain not just condescension but a certain contempt for civil society. One judgment says, and I read and reread the line to see if there was some typo in that line, whether something was missed, but no, it's there. That at the present juncture, civil society is not evolved enough in our country to make any kind of meaningful contribution. Another judge says in his judgment that it is quite possible that both civil society and the law minister can be influenced by extraneous considerations. Extraneous considerations. So, a deep distrust of the political class, which is bad for the constitution. The political class ultimately is the class which is answerable to the people, which is elected and which gets thrown out. Unlike we learned people who, once appointed to the bench, can't be removed except by a special majority of Parliament. There the Constitution is amended to say, no, instead of special majority, it will be simple majority, the court will strike it down. But here, in the context of judicial appointments, that special majority is said to be bad. Now, civil society, in my view, can be the ultimate savior in situations where judges and lawyers and the law minister gang up. Why is this judgment only thinking of others ganging up against judges? One is, it presumes that the three judges will think alike, which is not necessarily so, which is not the experience of the collegium also. On the other hand, the law minister is often a very eminent lawyer. It's important to remember this because during arguments in this case, people only thought of one particular diabolical politician who was the law minister. But there are renowned lawyers who are also law ministers and who are part of the same cozy club as the judges. That eminent senior advocate whose law minister today will soon demit office in the change in government, and he will be addressing these judges in court. So the law minister also has some self-interest. This judgment doesn't contemplate such a situation at all, and perhaps doesn't want to contemplate such a situation where three judges and one eminent lawyer gang up together to promote a person like them. And civil society can't veto this. Now, there was some political unanimity at that time. After all, this bill took concrete shape during the tenure of the previous government. I myself remember being invited to some consultations. It was only carried forward by the next government, maybe with a change here or there. It was passed with unanimity, but today the political situation has changed. I see little hope now for Parliament to reassert itself in the foreseeable future. I think we are back to where we were, and I think this unhappy situation is going to be with us at least for another 10 years, if not 20 years. But the debate must go on. The Constitution is not the property of lawyers and judges. A dynamic Constitution works only interactively with the executive, the legislature, in a state of creative tension, of course, but the Constitution belongs to all of us, and if it does, this judgment ought not to stand. Thank you.
we'll take some questions now. We have a fair amount of time, so we won't have to rush. Everybody will get an opportunity. I know one Singapore lawyer once told me that in a crowd of Asians, it's always difficult to get the first question. But once they start, it will not stop coming. So I think it'll also give Mr. Ramachandran a chance to, give his vocal cords a little rest and have some water. So we'll take 2-3 questions at a time and then give him an opportunity to respond. Jaina, and then there's a hand at the back. First Jaina, and then I don't know your name, sorry.
Oh. But should I be the sole person answering questions, or can distinguished colleagues like senior lawyer Mr. Suresh Pai also respond to some questions?
Questions, comments, responses, everything's possible.
Yes,
yeah.
Thank you. Thanks for the lovely talk. I just had a question when you raised the issue about the NJAC and the external people. Now, while I strongly agree that the way forward is to have external people play a role in appointment of judges, whether it is through an NJAC or through an opening out of the collegium or any other way, wasn't one of the big reasons why at least Justice Kehar said that this should be struck down was, the way I read it was not the fact that there were external people, but because there were no guidelines as to who these external eminent persons would be. There was no reference. At least the NJAC Act does not say civil society. It could be any eminent person. And so the nuts and bolts of selecting the eminent persons, how the, other processes of selecting and therefore, I think that was one of the main reasons to set it aside. And what are your views on that? And sorry, a connected issue was that even with the NJAC Act, there really was no requirement or emphasis on getting diversity in the judiciary. And so we're still stuck with the issue of a non-diverse selection.
Good evening. I'm Varun from Takshila. I'm not a lawyer. As a lay person or someone who's interested in public policy and analysis, my initial response was, of course, looking at the 1970s hangover of the mistrust of the political class and executive, and going ahead, it also was in a way the problems of nuts and bolts furthering that distrust in that basically how the NJAC appointment was being made. The problems with the nuts and bolts may be conflated and further the mistrust in the public perception. So how do you address that?
Thank you, sir. I have a question and a comment and a question. Just a short while after flipping through summaries of this judgment, I read in full the second decision in the National Company Law Tribunal case, where interestingly, the court now has ordered that a 5-member selection panel be made 4, where there was a predominance of the executive, and the 2 judges who will be the appointing authorities for the NCLT will have a veto. That's the second NCLT case in May, and it just struck a chord that there's some link here as to how there is this feeling that there is, yes, that's one. Secondly, if I could ask you, and a question was, if you know, crystal gaze a little more, And you have this idea that the moment you start making certainties as to what constitutes basic structure, you start elaborating even more, somehow the quote-unquote flexibility of the original constitution and the dynamism of the original constitution will get stultified. Where else do you see them removing brick after brick in your analogy without letting the wall collapse in their analysis, but strengthening their position? When I say there, I'm sorry, I shouldn't be saying it's us, not so much us versus them. It can't be, hopefully it will never be. But it's where do you see them pulling out, the judiciary pulling out bricks in the hope that the wall won't collapse and the political consensus won't gang up against them? How far will they stretch, will the judiciary stretch itself? And I think, I guess apart from that, you probably are talking largely to a group of initiates here. We're probably generally in agreement with you. It would be nice to hear some contrary views, but those are the 2 points. Thank you, sir.
I think I should start with the last question because that's the easiest also for me. That's the easiest also for me. I think Justice Chalameshwar's judgment is the most significant dissent since Justice Khanna's dissent in ADM Jabalpur. Not so much for its courage, because here Justice Chalameshwar was siding with the government in that sense, whereas Justice Khanna was going against the executive. But for its sheer intellectual honesty, its humility. When Justice Chalameshwar says, for instance, that it requires great conceit to think that only judges are equipped to select judges, that shows humility. It also shows the importance of some political exposure, the necessity for some political exposure